Legal terminology is very important for small business owners. Here, we'll discuss a few terms related to torts. Feasance is the doing or performing of an act. Misfeasance is a commission or omission, doing or not doing, of an act of duty without the intent to harm. Nonfeasance is the omission or failure in duty, or duty without action. Malfeasance is a commission of an act with the intent to harm. It's wholly wrong, and it may be unlawful and criminal. Nuisance is a condition which interferes with enjoyment of life or property. Remember, it's only defined in some states. A nuisance prevents ordinary comfortable use of your property. A nuisance may be offensive to a person of normal sensibilities. Or a nuisance may be inherently dangerous or defective. Remember that failure to correct nuisances may be treated as negligence. There's also a term called attractive nuisance. Take a look at the two pictures featured here. On the left you have a slide which is most likely in a public area. As you can see below the slide, the area is worn out, presenting in danger. On the right, you may have something that's on private property. Again, this is dangerous, but it may be attractive to somebody to explore and want to check it out. Each of these are a nuisance and may need to be dealt with properly. Another common tort term is negligence. Negligence is an act or failure to act as a reasonable person. To prove negligence, you have to follow some simple steps. First, was there a duty to act or a duty to care? Second, was there a breach of that duty? Third, was the breach of that duty the proximate cause of the injury? And fourth, you have to actually have an injury or loss. Here we have the 4 degrees of negligence, which you have probably heard of in the past. Slight negligence is the absence of degree of care used by persons of extraordinary prudence and foresight. Ordinary negligence is the omission of care used by a person of common prudence. Gross negligence is the intentional failure to perform a duty in reckless disregard for the safety of a person or a property. Willful and wanton negligence, and this is an intentional act of unreasonable character in disregard for any known risk. Here are some important issues to consider. What is the value of life impaired versus life lost? What foreseeable events may be an issue? Are there a statute of limitation in place? What liabilities do you have for your products or services? As an employer, are you a respondent superior? Are you responsible for the actions of your employees? As an employer or a place of business, are you in loco parentis? That means you have the responsibility in the case that a parent or a guardian is not there. Finally, what kind of waivers or assumptions of risk do you take on as an employer or as a business? Good Samaritan laws or charitable immunity laws are only protected when the service is properly rendered. Dram shop acts refer to the responsibility in the service of alcohol. Basically, when you're serving alcohol, you need to consider the safety of the person of which you are serving. If you're going to do any type of business, I would also look into the Uniform Commercial Code. And basically, this was to harmonize the law of sales and other commercial transactions in all the states within the USA. Again, take a better look into that. Do some research. There are certain legal defenses for negligence. First, you can prove one of the steps in a negligence did not occur. Remember, this all relates back to, is there duty to take care, and was that duty breached, and if that duty directly resulted in a real or sustained injury. Second, assumption of risk. Did the person participating or buying a good understand and assume a certain amount of risk? Contributory and comparative negligence. This is basically where the act of the person contributed to the negligence. And finally, an act of God. This is otherwise known as an act of nature. These are things that are beyond our control. A hurricane, a tornado, a flood, things of that nature. As a small business owner, what can you do to protect yourself against liability? The 3 things we listed here are insurance, professional practices, and education. Remember, insurance only protects against certain things, and there may be limits in place. Professional practices are the best practices or the peer practices, which are related to codes of conduct and standards. Finally, you have education. This is preparation and awareness to fully understand how you can safeguard yourself against liability, and really relates to the insurance and professional practices as well.